Hi everyone, Jay here from Flow Migration Law. Welcome back to the channel. Today, we're going to talk about something that's genuinely every applicant's worst nightmare. Imagine this. You've put your family's future in the hands of a professional. You trust them, but then silence. And when you finally manage to get an answer, it's not from them. It's from the Department of Home Affairs telling you that your partner visa was refused months ago, and you've been living in Australia unlawfully without even knowing it. This isn't a hypothetical. This is a true story of a family who came to us in exactly this situation, and today I want to walk you through how we navigated this incredibly complex problem. So let me set the scene. We had a wonderful couple with 2 young children. They built a life together over many years, starting in the UK. The applicant was here on a student visa doing his PhD at an Australian university. They had deep roots here. Applying for an onshore partner visa, the subclass 820, was the natural next step for them. They did what seemed like the right thing. They hired a registered migration agent to handle the application. But soon after, communication with their agent became a real problem. It was patchy, then it stopped completely. Their calls and emails went unanswered. When they tried to look the agent up, they discovered the business was gone and the agent had been deregistered. This is when the panic really set in. They contacted the department directly, and a Vivo check delivered the awful news. Their partner visa had been refused months earlier. The reason? The department had sent requests for further information to the agent, but the agent never replied. The application was refused simply because the requested documents were never provided. When they came to us, we had to quickly figure out just how bad the situation was. We got a copy of their file from the department, and the picture wasn't good. Here is what we were up against. First, the 28-day window to appeal the decision to the tribunal was long gone, so a standard merits review was off the table. Second, the applicant was unlawful. He had no visa. This is a very serious position to be in. And third, this created the biggest hurdle of all, the Section 48 bar. Now, in simple terms, Section 48 of the Migration Act prevents someone who does not hold a substantive visa, has had a visa refused or cancelled since the person last entered Australia from applying for most types of visas while they are still in the country. So he couldn't appeal, he was unlawful, and he was barred from simply lodging a new onshore partner visa application from within Australia. At this point, many would think their only option was to pack their bags and leave the country, separating the family. But the family was adamant. They wanted to stay together. So we had to develop a very careful and creative plan. Step 1 was to stabilize their situation. The immediate priority was to get the applicant onto a visa. We lodged an application for a bridging visa E or BVE. A BVE is a short-term visa that makes a person to hold a short-term visa in Australia while they sort out their immigration matter. Getting their BVE granted lifted that immense immediate pressure of not having any visa in Australia. Step 2 was the long-term solution. With the BVE in place, we focused on overcoming that Section 48 bar. The family did not want to be separated by having to go offshore to apply for a subclass 309 visa. So we did a deep dive into the law. The key was to find a visa pathway that is an exception to this Section 48 bar. There are only a handful of visas that you can still apply for onshore in this situation. After a thorough assessment of their circumstances, we identified a substantive visa that was not only an exception, but one for which the client had a good chance of success. We prepared a very detailed application, and thankfully it was approved. The grant of this new substantive visa was the real turning point. It completely reset their position. Because the applicant now held a new substantive visa that he'd applied for in Australia, the Section 48 bar no longer applied to him. This opened the door for us to do what they wanted all along. We then prepared a comprehensive, decision-ready application for the subclass 820 onshore partner visa. We made sure the evidence was well prepared, addressing all 4 pillars of the relationship. And the result was better than anyone could have hoped for. The department didn't just grant the temporary 820 visa. They gave them a double grant, granting both the temporary 820 and the permanent 801 partner visa at the same time. This is often done for couples in long-term relationships, and it means this family could finally bypass the usual 2-year wait and secure their permanent future here in Australia together. So what can we learn from this? First, a refusal, even in a terrible situation like this, is not always the end of the road. There can be creative and lawful pathways available. Second, choose your representative carefully. Whether you decide to work with a registered migration agent or an Australian legal practitioner, immigration lawyer, stay involved in your own application. The consequences of poor representation can be devastating. And third, if you feel something is wrong, act quickly. Get a second opinion. Time is absolutely critical in Australian immigration matters. This case really shows what's possible with a sound legal strategy and persistence. My work over the last 8 years has been dedicated to helping families navigate these exact kinds of processes, from the very straightforward to the highly complex. If you find yourself in a complicated situation, perhaps facing a refusal or a legal barrier like Section 48, we have a great deal of experience in this area and can help you map out a way forward. For complex matters like a refusal, you can book a consultation with me directly by emailing me at js@flowmigrationlaw.com.au. Thank you so much for watching. If you found this case study helpful, please give the video a thumbs up and subscribe for more Australian immigration content. We'll see you in the next one.